All right, so this is an important question that came across our Discord for you guys, or mostly for Matt, I suppose. Yeah, definitely the Colt All-American. But for what you can, obviously, we know that the Matt Hoover / CRS Firearms case is going through appeals right now. But maybe just your outlook and perspective on that case.
Right. So there's Hoover's case is very close to another case that people are talking about oftentimes just as much as Patrick Tate Adamc. And so let me give a quick rundown of these cases. Matthew Hoover, YouTuber, CRS Firearms. He at some point takes an advertising deal for these tchotchkes, these trinkets, the auto key card. It is a business card size thing onto which a design is lightly itched. Most gun people would see it as, looking like the outline of a lightning link, right? Never proven whether or not the lines are accurate, by the way. Never even litigated. The lines are so light you cannot even scratch it with your fingernail. They charged Hoover and the guy who was actually selling the cards with conspiracy to manufacture and distribute machine gun conversion devices. So I represented Hoover at trial, and me and my partner Zach, and then there was yet another attorney representing Irvin, and we all worked together. And the government really shot themselves in the foot because originally they charged saying, right, they looked at the statute, there's 5 different machine gun definitions. They charged it saying it is a part designed and intended solely and exclusively for converting a weapon into a machine gun. We moved to dismiss saying, obviously it is not a part, right? Like, and number 2, solely and exclusively, it has a bottle opener on it. It flatly doesn't meet the statute. And we even said, furthermore, they couldn't even shift to the combination of parts language, right? Because that's another definition, a combination of parts designed and intended to convert a weapon into a machine gun, because it is undisputed that these cards are singular, homogeneous pieces of stainless steel. The government then amends the charge to say specifically, each card is a combination of parts designed and intended, right? The trial goes on for over a week, and the jury returns a conviction. This is over multiple objections, tons of briefing on the fact that you cannot say combination of parts and then hold up a single homogeneous piece. And this was just ignored, right? That's one of the most important things. There are several different issues on appeal, including the fact that the government refused to engage in a Second Amendment analysis, which, it was kind of nuanced in this case, right? Where it's not, the argument wasn't straight, this is protected by the Second Amendment. It is, this isn't a gun, much less not a gun. It's not a machine gun conversion device. And if it is, then it must be subject to protection to Second Amendment protection, because if it is, right, it would be a precursor, right, related to the Second Amendment. And the government refused to respond to this. And so we should have won on that ground because they refused to respond. So there's a lot of procedural issues, and basically the prosecution was jammed, right, forcing through this theory that each individual, and again, I cannot stress this enough, that each individual piece of stainless steel was a combination of parts. And the jury let them get away with it at the end of the day, is what it is. So we're currently on appeal to the 11th Circuit. It's fully briefed. There's been a bunch of back and forth with the government. They've fought us tooth and nail, but really, I think we have a great position because it's not parts. That's the simplest one. But if you want to read all the positions, our briefing is available for free on Court Listener. If you look up United States v. Irvin, I can give you a link to put down or whatever. On top of that, the only evidence that they brought up at trial that this thing was a machine gun was that an ATF agent, did he cut up one exactly along the lines? Yes, he did. It didn't work. Did he cut up one a little inside the lines? Yes, it did. It didn't work. Then did he make another one, ignoring the lines, cutting it to the shape he thought it should be? Still didn't work, but he got it to induce hammer follow. Admits it was hammer follow, admits it was not functioning as a lightning link at all. And they still proceeded with that theory. So the government on appeal is saying it's like hammer follow means machine gun, period, end of story.
Right.
If that's the case, every single AR-15 contains the frame or receiver of a machine gun because you don't need to install the disconnector, right? And you get hammer follow without a disconnector. So their position is completely insane, and we've brought all of this up to the courts. So again, Hoover's case is about, this is a drawing, right? It's obviously not parts. Then we have a Adamc's case. A Adamc is a Navy sailor, right, who was like 26 years old at the time he was arrested. What happens is the government catches a guy who's a convicted felon. He's in possession of a firearm, right? And he's really deep in the gun community. And they say, all right, we'll let you go if you find us somebody on Gunbroker selling illegal machine guns, right?
This is the gentleman that had the flats and the RPG.
Yes, which were never charged. Yeah. But you are thinking of the right guy.
Okay, making sure.
So this person is like, I am going to go to jail if I don't find this. And naturally, shocker, no one is selling illegal machine guns on Gunbroker. Yeah. So he finds somebody who has saw cut parts kits and emails this person, is like, hey, I want this, whatever. And he's like, okay, well, yeah, I have these parts kits. Until like 2008, most of the parts kits that were imported into this country were saw cuts. They're fairly easy to weld together, but it doesn't matter because you've cut the receiver up. Right. It's not a gun anymore. It's disintegrated. ATF has never made a rule. There's never been an amendment to the law to say it has to be cut up a certain way or whatever. But so this convicted felon goes, I found a guy. Here it is. He's got the machine guns for sale. They're like, okay, buy them. They give him the money. And they also paid him additionally to do this. He buys the parts kits and says, see, I found the machine gun. And the government goes, okay, and raids his house. And what do they find? A bunch of lawfully possessed everything. He was a collector. When they raid the house, in his office, he had a legally purchased, that he did a 4473 M79 receiver with a dummy barrel on it. Same legally purchased M203 receiver with a 37 millimeter barrel on it. Totally legal to have. On the opposite side of the property, locked, right, 40 millimeter barrels. But people might say, oh, that's constructive. No, it's not. It never has been found to be as such. What the ATF did is they assembled them.
Yeah.
ATF just assembled them, didn't even mention the fact that that's how it was, and just said complete rocket launcher, or no, complete grenade launchers. Mm-hmm. Then he had 2 RPG anti-tank projectors with holes in them, no fire controls, and in very large red letters, training aid dummy inert.
Correct me if I'm wrong, but he even flew from California to Virginia with that in his carry-on, and TSA had zero problem with it.
100% correct. But so what ATF did was they said, that's a rocket launcher. And you know how we know it's a rocket launcher? Because we took what?
They sleeved it with a 7.62 by 39 and then replaced the trigger.
Yeah, they took out the aluminum fire control, went into the reference collection and got a Russian RPG-7, installed the Russian RPG-7 fire control, admitted there's a hole on it. If we fire a rocket, it will remove the user's head. So they used the 7.62 by 39 trainer, which is a gun, right? It has its own chamber and everything, and fired it. And they said, that's a fully functioning RPG-7.
Yeah.
And so
rocket launcher, why rocket launcher shaped?
So that's, you see, the 2 cases have the same problem. The government is saying this is complete X, Y, and Z when it clearly isn't. So in a Adamc's case, that's in the 4th Circuit. The 4th Circuit has openly said, we're waiting for what the Supreme Court is going to do in Vanderstock, which is the 80% case. Cooper Kirk lawyers didn't do that great on that, but we don't know how that's going to come down. I don't think it fully controls, because that's about an administrative rulemaking specifically, like that would actually be giving you some notice of what they think is restricted. What these cases were them using, the ATF using the language that they ultimately put in the framer receiver rule, which is readily, identifiable as a precursor part to a firearm, which was never published before. And using that for the first time in a criminal prosecution. Even if the rulemaking is okay, how can it be okay that the first time we hear about an interpretation of a criminal statute is in a criminal prosecution?
So my thoughts on that is I think that they were trying to push it through to try and their best hand at trying to set legal precedent. That's what I thought that was. I thought that they were trying to use their vague rulings to set legal precedent on a case that they could then use going forward to try and go after other people.
And they've gotten away with that same exact thing before, right? Whenever we're doing the research on the M14 stuff.
Yep.
Now, the guy they got for this wasn't a fantastic guy. He was doing some stuff that was probably actually illegal.
He was being a silly goose.
A little bit silly, but they specifically will target people they think they can get convictions on that give them favorable legal precedent, because it lets them get the thing they want without having to have Congress give it to them, because Congress giving it to them is hard, and it's subject to public scrutiny, which makes it doubly hard. But if they can just
Congress would give it to them hard.
If ATF can just get the facts in a case just right, that there's a solid chance that a jury can be confused about what's going on, they're able to effectively railroad people to get the the legal land work set the way they want. So cut up, right, because the M14 case dealt with completely cut up M14s, right? So M14 receivers that were all cut up, the guys that went to remanufacture them would take the part that has the auto sear lug, right? That's the part that it's the third pin equivalent on an M14. If you're used to AR-15s with the third pin hole being drilled, on the M14, it's the presence of the auto sear lug, the lug that would accept the selector switch. Now, the company that was remanufacturing these M14s took that lug, filled it up with weld, right? Filled that all the way up with weld, so there's no way that you're going to put any parts in there, then welded the receiver back together and said, this is a new semi-auto receiver. That lug is non-functional because the hole isn't drilled in it. And then ATF said, well, with 8 hours in a machine shop, you can take a tungsten carbide cutter on a mill and drill a new hole through this hardened weld. And the courts let them get away with this, which is hilarious and nonsense, but it's the reason.
Well, it was a little more nuanced in the M14 cases. They didn't fully get away with that, but they railroaded the guy and put him through the ringer there, because we didn't get final resolution of that case.
Quick question on all this. Firstly, on the Hoover, do you think that with the jury returning a conviction, a guilty verdict, do you think that just because they just default to whatever the prosecution's expert witness says, were you guys limited in the ability to call your own expert witnesses or anything like that? I mean, I think it's clearly a political prosecution, and a legitimate political prisoner. I just want to hear you guys' thoughts on that. And
so, I have heard, and I want to address that right away. A lot of people without credentials have whinged about the Hoover case, saying that there should have been character witnesses or additional things brought up on a defense case in chief. And they blame me for that. Meanwhile, there was 3
I'm not
attorneys.
doing that for the record. I'm just trying to.
Yeah, no, I know. I'm putting this out there though. There was 3 attorneys on the case in the courtroom, all in unanimous agreement that the government has made a hilarious number of unforced errors. Like, they have hung themselves by agreeing that they had to materially alter the cards, agreeing that it didn't function as it was designed and intended, agreeing, right? Like, all of these things. If you go up to reinforce these things in your rebuttal case after you've already pointed out the failings in your motion for judgment, right? You give them the opportunity to fix this. Not a single lawyer that was there, of the 3 attorneys, there was not a hint of disagreement, and all of the clients were in agreement. This is the way it should be done, right? As for what the jury ultimately said, look, I have nothing to say about the jury. At the end of the day, there is a trial risk, okay? And it's a bunch of random people. You don't know what they're thinking. You will never know what they're thinking, especially when the government brings its case so haphazardly that you don't know what theory they're convicting on, right? And that's the case in the Adamc case, because in the Adamc case, it was the opposite, where instead of focusing on one definition, they just said it could be any kind of machine gun. It could be a combination of parts. It's a functional machine gun, or it could be readily restored, or it could be this or that, which is constitutional notice problems.
Isn't that
there's a massive CSI effect. There is a massive CSI effect on juries, but like, look, what was happening at that trial? The final 2 days of the trial were literally the government's experts falling apart, agreeing that nothing worked, agreeing that the only time that the device did anything was when one guy completely ignored the lines and made it cause a malfunction that is completely unrelated to the design of the gun. You go to the jury box with that, and you're feeling. I will tell you this: we were very surprised to see a conviction in that situation. And that's why we feel good on appeal. And Matt, by the way, I don't know how this man has such spirit. I talk to him very often, and he's always smiling. He's confident. And he's a Christian, and he has faith. He has complete faith that God has put him in that position for a reason, and he has complete faith that he will be, his rights will be vindicated. And so do I. I hope it happens right now, right? And I hope that we don't have to keep on fighting for it. But I can tell you this: I'm not going to stop fighting for him no matter what. And John Crump has been also great, and he's been behind us in this. And I can tell you who hasn't: any of the gun rights groups. Not done a motherfucking thing in any of these cases, aside from tacitly try to steal credit at the last second. But there are great people, it's not just me, who are putting their heart and soul into taking care of these guys. And the only thing, the recognition I think should go right now to Matt Hoover's family. I think if you guys want to send money somewhere, please send it to his wife because she has kids. He is Matt Hoover's a political prisoner. He understood, he's obviously the target, right, of their ire. His children shouldn't be suffering. So that's, I think, the biggest, most horrible thing here.
What's the best way for people to support Matt in this venture right now? What's the best way to directly support him and his wife? Yeah.
So if you go to his channel, his wife's still running the channel. And they're constantly having their different links taken down or whatever. So you're going to want to go to the channel and see, and they're very conservative about it. She doesn't ask for money all the time, but she'll have links on how to support her. And I would just directly, I would directly financially support her.